My name's Brennan Swain. I'm here with Rod Berman. We're both attorneys at JMBM. We're going to be speaking today about wearable technology. So, Rod, we've all heard about wearables, but what is it?
So wearable technology normally would be considered to be anything that's wearable that has technology. Years and years and years ago, that would simply be a watch. Today, it's iWatches, Samsung watches, monitors for baby breathing, sports devices, any type of device that is wearable, which typically involves some aspect of fashion and technology.
So we've heard a lot about it in the press recently. Why is that?
I think it's just gotten very, very popular. Apple had developed a technology which allows the incorporation of lots of functionality on chips. So they were able to make very, very small chips, which allowed the making of the iWatch. And the iWatch, together with the Google Lens and Fitbit, sample of Fitbit here, have just caught on to athletes and the public, and even medical device manufacturers, police, lots of people.
All right, and what type of lawyer is needed to protect wearable technology?
I think a very seasoned intellectual property lawyer. Today there are lawyers who specialize in patents, and some lawyers specialize in copyright, some in trademarks. I think the best lawyer to have is somebody who appreciates patents, trademarks, copyrights, trade dress, packaging, maybe even knows a little bit about privacy laws, because a wearable embodies all of those areas of intellectual property.
And what in particular gives you qualifications in this area?
Well, I've been a patent lawyer for 30 some odd years. I work with you, a mechanical engineer. I work with others in other technology, including software. Spent years dealing with trademarks and trade dress, represent lots of clients in a variety of industries throughout the world. And I think it's that overall look, not just on my part, but on the part of those in our department, other lawyers at our firm, that helps make our wearable technology practice at the very high end of first rate.
And what does a company have to do to protect its investment in wearable technology?
So I think the first thing the company has to do is recognize that the only practical way of protecting that technology is through intellectual property. And at the conceptual stage, they should either deal internally with in-house counsel or contact lawyers such as us to evaluate the possibilities of intellectual property protection. It could involve patenting the technology. It could involve branding the name. It could be involved the packaging and how the packaging looks. It could involve copyright, the instructions. There might be aspects of it that are best protected by contract. And if you take a look at the Fitbit, for example, you can see that the packaging has language on the back and the front that's copyright. Obviously, Fitbit is a trademark, it's a name. The Fitbit device itself is covered by patents, whether it's on the band or the actual computer software inside the device. So it involves all those aspects of intellectual property. And because there are certain time frames in which to protect that intellectual property, it's important that a company recognizes it and contacts someone who is knowledgeable in the area.
And speaking of time frames, what are some of the things that someone would need to know about how quickly they need to seek protection?
Well, probably the most important time frame is patent time frame. In most foreign countries, and we assume that the wearable technology will be sold outside of the United States, patent applications have to be filed before there is any public disclosure or commercialization. In the United States, under certain circumstances, you have a 1-year grace period, but in general, you have to promptly file patent applications. Trademark applications are similar in some extent. You can file a trademark application at any time, but the date of filing of a trademark application gives you potentially worldwide priority. So it's important to file a trademark application quickly, and if you're going to file applications outside the United States, to file within 6 months of your U.S. filing. Copyright applications are also important to file right away, because once a copyright is registered, the copyright owner gets additional rights that don't accrue if the copyright is not registered.
All right, so for filing patents and trademarks, those are kind of offensive filings. What can a company do to protect themselves from being sued if they start selling wearable technology?
There's a variety of things they can do. For the most part, it focuses on trademarks and patents. So they should conduct a trademark search through lawyers such as us, to make sure that the mark is available, at least in the United States, and potentially conduct searches in foreign countries as well. Fitbit is a perfect example of a company that launched its product, and shortly after its product was launched was sued by another company who had a similar name in connection with a similar product. Case got resolved, but searching wasn't presumably undertaken as thoroughly as it could have been. Patent searches are important from two ends. One end, to make sure that you have the freedom to operate so that you're not infringing anybody else's technology, and also to determine whether or not your technology might be patentable. And you could be certain that companies like Apple and Samsung are incredibly active in filing patent applications. Probably, in wearable technology, it's not simply the electronic components of the device itself. It might be the material used for the band, the particular shape of the device. Again, software functionality as well. And it could be the appearance, because patents, as you know, cover both utilitarian features of devices as well as their design feature, what they look like. And again, if you conduct a search of just the US Patent Office on what Apple has filed for the eyeglass, you'll see a plethora of patent applications. Every single aspect of the device is sought to be protected.
All right, and so lastly, what do you think the future holds for wearables?
Well, it's kind of iffy right now. We're at the beginning part of the growth of wearables. From a technical standpoint, I think wearables will be more lightweight, more functional, more user-friendly. The issues that are going to arise is there a real market for wearables? Apple had once predicted selling $2 million worth of Apple phones a month, and I'm not too sure whether they've met their predictions, although most pundits believe that it's ultimately a $30 or $40 billion industry. The other issue that we have to look forward to the future is privacy, because the concept of wearables is not just the functionality, but it's interactivity with other devices. And that brings to mind the privacy issues in collecting personal data, which goes back to one of your first questions, is why is our practice particularly focused on wearable? We have the intellectual property aspect of it, and we have attorneys who handle the privacy aspects of it too.
Sure.
So one package.
All right, well, thanks for that great information. Anybody watching this, if you're interested in learning more about wearable technology, you can contact either Rod or me through our information that's right on the screen. Thank you.
Thank you very much.
We hope you found this video informative. Please watch our other videos at Jeff or Mangels YouTube or jmbm.com.